to trial. Take it to trial. Welcome in, grab a seat, hit the like and subscribe. Cause Sweet P's on the mic with that spicy little vibe. Got the courtroom streaming in the chat, going wild. We're debating heavy topics, but still laughing like a child. From objections to confessions to the judge's side eye. If it's justice and it's messy, we gon' talk about why. Every day's a new case, every moment's a ride. And when Sweet P's in the building, we be learning with pride. My eyes on deck, keep the room running smooth. Film freak therapist, you know, keeping everyone in the groove. Like to with the facts, pretty brown girl with the sass. Morelia and Fowler keep the peace in the chat. But Jason walks in and the ladies collapse. Chocolate, take it to trial, where the truth gets loud and the laughs run wild. Sweet P's got the spice, she's the queen of the aisle. Chat fam rolling deep, we've been here a while. Lights on, mics up, we gon' do this right. Take it to trial, every day, every night. Take it to trial. Morning shows are sharp, afternoon is on fire. And we catch every moment that the court might inspire. From witnesses whispering, the lawyers trying to hard. You know Sweet P breaks it down like a legal tarot card. Chats cracking jokes, dropping theories on the fly. We're serious when it counts, but we still testify. Minds hold it down when the trolls try to play. If you're out of line, court adjourned for the day. But when Jason logs in with that deep hello sound, the ladies in the chat, man, they all fall down. Take it, 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 take it to trial, where the truth gets loud and the laughs run wild. Sweet P's got the spice, she's the queen of the aisle. Chat fam rolling deep, we've been here a while. Lights on, mics up, we gon' do this right. Take it to trial, every day, every night. Take it to trial. When the sun goes down and the cases get deep, after dark gets spicy, no secrets to keep. Taboo topics, big laugh, slap, happy crew. Sweet P says behave, but we never really do. It's opinions, confessions, stories untold, but we handle it with heart like the chat made a goal. Hey! Take it to trial, from day to night and every wild mile. Sweet P's nearly strong with her trademark style, and the fam in the chat always makes it worthwhile. Turn it up, show some love, hit the like on sight. Take it to trial, yeah, we live tonight. Take it to trial, yeah, we live tonight. Take it to trial.
Oh boy, oh boy, oh boy, oh boy. God damn. That about got on my nerves. I don't judge. Okay. Let's start here because I hope everybody made it over here safely. Look, safely, all in one piece. So we've been hearing a lot about this 412 stuff. Like, what the? So this is this 412 stuff that they're trying to get in. Because it's more. It's not just her statement. Let me get to her. I'll do her statement first. Okay, here we go. That's her, Ashley, Miss Ashley Hall. Okay, so this is her mess here. Just so we aware of what we got going on. Okay, let me get into this. Let me make sure I got everything set up on this end. Make sure we live in all the places that we need to be live on. Like, so over. My guy here, I mean, like, he really got ridiculous at the end, but whatever. I mean, because now I'm like, okay, I don't want him to seem like he pouting and a crybaby. Like, he doesn't even speak to me in the hallway. Okay, Mr. Cruz, like, I get it. I know we want to be respectful, and we want to get along in certain ways, but everybody just don't have that, you know. He seems like he's pretty nice. He seems like he's one of those people that he'll speak to you no matter what, but if you don't speak to him, it kind of like, it gets in his feelings a lot because he's giving you all the respect that he can possibly give you, and it's just not in return sometimes. And yeah, my guy, sorry. I know. We don't like stuff like that. If y'all can remember to hit that like button as y'all come in, I would truly appreciate it. I know we switch rooms, but I do want y'all to hit the like button for some reason. Just maybe because. Hey Frank, how you doing? Okay. So that would be awesome things there. Okay, so the first one that I'm gonna go over, and then we'll get to why I think this trial is just gonna be a whole mess as we go along. Unfortunately, my guy feel like he defeated. He ready to hit his head on the wall and everything. My poor guy, he is just so over this. You know, he feel like he in handcuffs. He feel like he in Russia. Like he got that kind of stuff going on. Okay. So this is in regards to that 412. So the defendant, through his counsel, they were trying to get this 412. They provided the state with a notice in advance of the trial scheduled for January the 26th. The defendant's intention to present evidence of statements made by Mrs. Tara Baker, who is the deceased victim in this case. Now, the particulars being shortly before her death, Miss Tara Baker confided in Miss Ashley, y'all know that's Miss Smarty Pants on the stand, that Chris Melton was not considerate and that she was doing a lot and Chris was not reciprocating. She didn't feel appreciated. Miss Baker expressed her frustration to Miss Hall, Miss Ashley Hall, advising that Chris Melton wanted more time with her, but Miss Baker was unable to give it. Miss Baker told Chris Melton that she would be home alone the day before the unaliving. Now, keep this in contact that she was unalive right before her birthday. It appears that the way her body was found, and just hear me out, guys, this may not be, just hear me out. So the way the defense is presenting it is that, hey, whoever was in the house, she knew. The house was deadbolted. It was no forced entry into the house. She was completely asshole naked, right? She had just washed her hair. The fireman testified that he could still smell the shampoo in her hair. So he just couldn't call what shampoo it was, but he could still smell the shampoo in her hair. So it makes me feel like it was somebody that she was comfortable over there being with. Now, her and the boyfriend, Chris, they had an altercation a week before. Now, with the defense putting in those photos of Chris' hands, like, I don't know how we get away from that. I don't know how we reconcile all of this stuff. Like, this is so much reasonable doubt. And if y'all gonna tell me because a little piece of DNA that they found up in her, I don't even know where they found the DNA at this point in time, because you know why? Because all the damn swabs is messed up. We don't know where the swabs went to because they incorrectly named them. Like, we got 2 oral swabs. They saying they did a JJ one and they saying they did a butt one. I don't know where the swabs came from. So I got a whole problem with all of that. So I just really think so. They want to get these statements in. right? And this is the problem that they're having, and this is what they keep fighting over. So that is the statement that they're trying to get in from the witness that's currently on the stand. They're trying to get that in front of the jury so they can understand that, look, her relationship with him wasn't that perfect. And then on top of that, we had another witness that came here and testified yesterday that only knew our victim for 6 months and claims that she's the best friend, but these are not things that she told her in regards to her boyfriend. So, okay, so that's problem number one. Okay, so now that's one of them they're trying to get in. Now let me get the next one that they trying to do. Okay, so here is another. This is another 412 that they're trying to get in. This is this hearsay testimony. This is the state. They want to let the state in advance that January 26th, the defendant Tara Baker, that particulars being shortly before her death, that Miss Tara Baker called Miss Virginia Baker and told her that Chris Middleton and her were on and off. So she had disclosed to Virginia Baker that her and Chris was on and off. Wednesday prior to her death, Miss Tara Baker called Miss Virginia Baker and stated that she did not want Chris Middleton to be at her birthday party. So she didn't want Chris to come to her birthday party. Miss Baker told Miss Baker, oh, this is her mom. This must be her mom. This must be her mom. So she was telling her mom that she didn't want Chris to come to her birthday party. Miss Baker complained that Milton, which is Chris, would not go to school, wouldn't do anything, and was using her money to pay for his boat. So she felt like Chris was using her to pay for her boat. And the defense wants to get this testimony in. And what the judge has ruled is like, in a way, like, oh no, y'all can't get that in unless y'all get it in through Chris, because we can't bring in these hearsay statements through any of these other witnesses like we just heard from Miss Hall, and also in regards to coming in through the mom whenever the mom takes the stand. Yeah, it sounds like Chris was a capital loser, right? And she was tired of him taking advantage of her. Okay. So the defendant intends to offer her statements through other testimony, and they want to bring it through the mom. We haven't heard from the mom yet. So that's another person that they're trying to get testimony through. Okay. We got one more in here. Let me get that one up. Okay. Oh, wait a minute. Is it sharing this one? I wanted to share this one. Okay. Is it sharing this one? Okay. Okay. Now, this next one that I'm going to be reading over is... Gonna blow this up some. Shoot. Okay. This is another statement that they're trying to get in. Tara Baker, our victim, expressed to Dr. Valerie Lane that her relationship with Chris Middleton had become a distraction. When Ms. Lane inquired into whether Ms. Baker was okay after noticing that Ms. Baker had noticeably reduced the time she was spending with Chris Middleton in the weeks preceding her death. So it's Dr. Valerie Lowe. I don't know who that is, but according to them, they're saying that the victim, she was talking to this doctor in regards to her relationship with Chris, and that it was a big distraction, and she wasn't spending that much time over there. Okay. So they want to offer that statement in there. We haven't heard from this doctor, I don't believe yet. So we'll see how that happens. So that's how that works. Okay, cool. So we got that. Those is done. So just so y'all can understand this 412 evidence and let me see. And that's in regards to these hearsay statements. So I'm assuming that we're going to be going back and forth in regards to this. So I can only tell because remember, we only get into the first person that we having all these issues with. And remember, this is why he got order of contempt because of this. Contempt because of this 412. So let me see, make sure. Okay, so our next thing that I wanted to show you guys. Let me get this up so y'all can see it. Share. Okay, so here we got it. An order of assignment for motion for disqualification or recuse. So it's saying the undersigned, having received a request from the Honorable Lisa Lott, Chief Judge of the Superior Courts. So she's the Chief Judge of the Superior Courts of the Western Judicial Circuit, for the temporary assistance of a judge in order to provide for a speedy and efficient disposition of the business of aforesaid court. Let me see. Is this the order? Okay. It is ordered that Honorable H. Patrick Haggard, I don't know if this is going to be Haggard because it got this authorized judge of the Superior Courts of the Western Judicial Circuit, is hereby designated and appointed to serve and conduct proceedings for the motion in the above style case. Okay, this is on January 20th. Okay. I had them all up. They in my other little thing boxed all up. So wait a minute. I even got the thing with the jurors questions. We can look at that too. Okay, here we go. Okay, so this is the actual removal. This is what they wanted. It's 27 pages. They wanted the judge off the case. This was filed January the 16th, 2026. So this is even prior to the case even happening. And I think this is where all the tensions come in. Because remember, when you ask for a judge to be removed off the case, guess who decides if they get removed or not? The judge. So exactly, this went to the judge, and so now she already knows that whatever they salty with her about, she know what they salty her about. She knows, right? Because they put it in here. So let's see where we mentioned again. I take it to trial. Where? Oh no, we didn't do anything. Did we get in trouble somewhere? I don't know. Did we get in trouble somewhere? Marilda, I don't know. Oh gosh. Okay. Okay, so here we go. Oh, I was about to say, oh gosh, don't tell me y'all done got in trouble again. No, I stay in trouble. So this is the motion that they wrote up in regards to disqualifying. They wanted the judge removed. Get her off the case before we even start. We already see that we in handcuffs. This is Russia. This is not the way it's supposed to be. We don't want no parts of this judge at all. She already showing us that she can't be fair. My client is not going to get a fair trial in this courtroom. Okay? So now comes the defendant, our guy, Edrick, with his counsel, and they asking for the judge to be removed. In support of this motion, defendant shows the honorable court as follows. The motion is timely filed, so they let you know, hey, we're filing this in time, which provides a filing and presentation to the judge shall not be no later than 5 days. Okay. Let's see. After they first learned of the alleged grounds for disqualification and no later than 10 days prior to the hearing of the trial, which is subject of the recusal or disqualification, unless good cause to be shown for failure to meet such time requirements. Now, we know that they probably made the time frame, so we'll continue on. It says that these alleged grounds for recusal on January the 15th, 2026, and our hearing date is not scheduled until January the 21st, 2026. So we accent early. We don't want her on this case. On January 15th, 2026, the Honorable District Attorney Kaliki, I guess that's his name, I don't know, Kaliki, Yamaha, I don't know, the prosecutor, the one that he don't speak to him in the hallway, he up here. Him and undersigned and Mr. Edrick Faust appeared before this honorable judge, Lisa Lott. She's still honorable, right? Honorable. That's very important that when they put honorable, because when I seen Judge Glanville get his motion to be moved off the bench, they stopped calling him honorable. They just said Glanville. I don't even think they call him judge. They was done with him. So she at least still getting her honorable. Judge Lisa Lott for the motions hearing on 1:30 p.m. calendar. Now, during that hearing, they're saying Judge Lisa Lott failed to follow applicable law and continued her pattern of violating Georgia's Code of Judicial Conduct Rule 1.1. Judges shall respect and comply with Rule 1.2, promoting public confidence in the judiciary. Let's see here. What is the judicial conduct rule of 1.1? Let's see. Let's see what law they talking about. She broke. Okay, that's just basically saying that it mandates that the judge must respect and comply with the law, including the Code of Judicial Conduct. Okay, they got the definition in there. Cool. All right. I just want to make sure we weren't missing nothing. During the January 15, 2026 hearing proceedings, the court instructed Mr. Faust through counsel that he was not to file any legal briefs following rulings by the trial court. Undersigned counsel cannot follow said directive, as same would violate professional rule of conduct 1.3, which provides a lawyer shall act within reasonable diligence and promptness. I think it's going to be promptness. I don't know. I got this unauthorized copy. In respecting a client, reasonable diligence as used in the rule means that the lawyer shall not, without just cause to be detriment of the client, in effect, willingly abandon or willingly disregard a legal matter entrusted to the lawyer. Comment 1 explains a lawyer should pursue a matter on behalf of a client despite opposition, obstruction of personal inconvenience to the lawyer, and may take whatever lawful and ethical measures are required to vindicate a client's cause or endeavor. A lawyer should act with commitment and dedication to the interests of the client and with zeal and advocacy upon the client's behalf. The court's instructions to Mr. Faust counsel was unlawful, and improper, and it followed would obstruct Mr. Faust's building of an appellant's record and deprive Mr. Faust of constitutional rights and to effective assistance of counsel. So, what she So additionally, on January 15, 2026, the court refused to reconsider its order denying Mr. Faust's amended motion to suppress evidence obtained due to illegal searches and seizures, hereinafter a motion to suppress the evidence, despite the state conceding that the law was unfavorable to the state's position during a prior hearing. In regards to the motion, on November 13, 2025, the following exchange occurred in regards to that motion. So here we go. Mr. Bowden, with what I'm trying to explain, there's a motion to suppress that Mr. Cruz filed on October 2nd. The court. Okay. Mr. Bowden, the second part of the motion to suppress is they then use the cell phone information to have a Georgia State trooper pull Mr. Faust over for the purposes of obtaining surreptitious DNA sample. Okay, so are they saying that they had somebody just pull Mr. Faust over at some point in time just to get a DNA sample from him? Is that what you're getting? Is that what I'm understanding? It's saying the second part of this motion to suppress is they then use a cell phone information. They use that cell phone information to have a Georgia State trooper pull Mr. Faust over for the purposes of obtaining a surreptitious DNA sample. So they just pulled him over so they can get a DNA sample. So they can plan it with the rest of their evidence. Got it. Okay. So they didn't pull some stuff off. Now, Mr. Bowden, the state is going to concede that the controlling case law on the stop by the trooper is adverse to the state's position. The court. Okay. Mr. Bowden, so that part of the motion to suppress, we're not contesting. Okay, so they're not contesting. Mr. Bowden, we are conceding that anything related to the trooper Wooten's traffic stop should be excluded. Okay, so they excluding it. Okay, all right. Mr. Cruz. Oh man, why I do that? That was stupid. Wait a minute. Okay, Mr. Cruz, will a written order granting the motion to suppress come out, or how would the honorable court deal with that? Now that how will we respond to the motion during the status? The court. Let me look at the motion first before I answer that question. But of course, Anything that the state either concedes or stipulates to, vice versa, will certainly put in writing, but I need to take a look at what the motion says. Okay. So she's saying she's going to take a look at it, but if they stipulate to it and they not disagreeing with each other, they are good. Okay, so they're saying, hey, the court not only refused to reconsider its decision, but the court also refused to provide Mr. Faust with a hearing on any ground alleged in the motion, despite advisement that the motion was conceded by the state. Shockingly, I think this is going to be shockingly, I'm going to say this, the court refused to reconsider its ruling. Okay, so counsel for Mr. Faust earnestly believed that the court had mistakenly denied the motion. However, once the court made clear its position, Mr. Faust's counsel realized that the court intentionally decided that the motion in favor of the state, despite the state conceding the issue. Such a blatant disregard of the law in favor of injustice was terrifying for Mr. Faust. Remember, he keeps saying that he's scared. He's scared. His client's scared. Mr. Hall's scared. The family's scared. Everybody's scared of this court because it's not going to be fair. So it's terrifying that he got to be in this courtroom. Mr. Faust and his undersigned counsel has expressed it was a mistake. However, the court's action made it clear that it does not care about fairness of the Mr. Faust trial, nor whether he's innocent, but solely on obtaining the conviction. The court's action supports the court's disqualifying herself pursuant of Rule 2.1, because they send all this stuff to the judge, and the judge get to look at it and tell them whether they think that they should be disqualified. They're not disqualifying themselves. Let's see. Says on October 2nd, 2025, Mr. Faust filed a motion to exclude Larry K. Peterson and any other microscopic hair analysis expert testimony pursuant of the Daubert versus Merrill Dow Farm. Instead of granting Mr. Faust a hearing or a ruling on his merits of the motion after the state advised it would not call Mr. Peterson, the court initially denied the motion because the honorable state stated that it would not call Mr. Peterson. Then orally stated that I want to say that it would suppress the evidence because the honorable state advised that they would not call the witness, but then told the undersigned counsel that in the event that the state changed its mind, then at that time, the undersigned counsel could make a motion. An impartial judge does not set a motions hearing deadline, then refuse to rule on a defense motion filed before said deadline because it may be detrimental to the state or because the state may change its mind. The court has had no regard for Mr. Faust's position or knowingly what the evidence would come in or be excluded at trial. The court's ruling focuses on protecting the state's ability to do what it would like to do during the trial at the expense of Mr. Faust's rights and trial preparation. You son of a guns. They are something else. Okay, let me go. Wait a minute, y'all. Let me go get some water. I didn't know it was 27 pages long. I'm so crazy. Had to give me some water. Hey, to anybody that just coming in. Hey. Yes, the person is in prison, Barbara. They have been in jail since 2024, honey. Hey, Susie. Okay, on November the 13th, 2025, the court held a hearing for the admission of other essays. X. This hearing was for the purpose of the state to obtain permission to admit Ms. Brenda Sweeney's allegation that Mr. Faust was S.A. violent towards her on multiple occasions. Whoa. Okay. All right, Edrick. I mean, I know you were not walking a perfect line. I know that you was out here doing some hood stuff. But whoa. Okay, so now Miss Brenda Sweeney's allegation that Mr. Faust was S.A. violent towards her on multiple occasions. The undersigned counsel has spoken with Miss Sweeney, and Miss Sweeney admitted that she does not recall a single incident. Okay. Mr. Faust being S.A. violent towards her. Okay, so she cleaning his name up. Mr. Faust lawfully served Ms. Brenda Sweeney with a subpoena to appear at our SMEX Other Acts. I guess I say it that way. SMEX Other Acts hearing. At the start of the hearing, Ms. Sweeney was nowhere to be found. She didn't even show up. She said, forget that mess, I'm done. Undersigned counsel explained to the court that Ms. Sweeney had been subpoenaed and that Ms. Sweeney's testimony would be that, to her recollection, there was never any S.A. violence between her and Mr. Faust, and that the statements that were made were due to being led by the police into making said statement. Undersigned counsel asked the court to enforce the subpoena for Ms. Sweeney's testimony. Despite this witness being lawfully subpoenaed, the court denied the request, depriving Mr. Faust of the compulsory, oh my goodness, process in the favor of admitting the state's evidence at the expense of Mr. Faust's rights. Wow. During Mr. Faust's November 13, 2025 motions hearing, the court told Mr. Faust's counsel that a lawfully made speaking objection was not a thing, depriving Mr. Faust of the use of the lawfully made objection. Oh, that sounded crazy. Let me read that over because I don't even understand what the hell I read. Y'all know I get confused. During Mr. Faust's November 13th, 2025 motions hearing, the court told Mr. Faust's counsel that a lawfully made speaking objection was not a thing, depriving Mr. Faust of the use of a lawfully made objection. Okay, so now he's about to say what it was. Mr. Cruz, speaking objection, Your Honor. Objection, speaking objection. The court, I'm sorry, what? Mr. Cruz, speaking objection. I'm objecting to the speaking objection. Tell him to be quiet. He's speaking. The court says, tell me what you mean by that. Mr. Cruz says, sure. So, speaking objection, a proper objection is an objection. Relevance, objection, hearsay, objection, lack of foundation. This is a speaking objection. This is an objection where you're making an argument. I object to the speaking objection. Oh gosh, was he trying to tell the court what a speaking objection was? The court says, okay, Mr. Cruz, I'm just going to tell you right now, that's not a thing. I am going to overrule that objection. She said, that's not a thing. Mr. Cruz, as usual, I understand. Oh my goodness. That is so funny. Let's see. On November the 13th, 2025, the court denied Mr. Faust the opportunity to proffer excluded cross-examination questions onto the record as it is required for appellant review and authorized, and then they cited and required to raise the legal error on appeal. The exchange was as follows. The court: I am going to sustain that objection. Mr. Cruz: yes, ma'am. The court's indulgence. All right. So for the purposes of the record, that concludes my examination. But just so, proffer the questions that would have been asked. I would have asked the detective after the court steps in. I'm sorry, what are you doing now, Mr. Cruz? Mr. Cruz: just proffering for the record the questions that I would have been asked. The court: I'm not going to allow you to do that. If you don't go have several seats, Mr. Cruz, we're not about to play those games. On November the 13th, 2025, the court ignored clear legal procedure that if a party is seeking to proffer evidence in an other acts hearing and the opposing party objects, said evidence must be presented by the means of traditional evidence. So, Mr. Faust provided the honorable court with case law, Benford versus State. We ain't going all the way there. Omitting other acts evidence because trial court allowed state to proffer other acts evidence over the defendant's objection to the same. So they saying that when they was trying to proffer a witness, the judge objected. So far we got when they tried to proffer a witness and ask some questions, the judge did not allow it. They saying that the judge told them that speaking objections is not an objection. They also said that they had a witness up under subpoena that did not show up for court. They asked the court to impose a subpoena, and the court did not assist them with that. Okay, so the court's pattern of conduct has also extended to communications between Mr. Faust's counsel and the honorable court. On October 2nd, 2025, the undersigned counsel sent the honorable court a motion and proposed order for the court's consideration before Mr. Faust's filing deadline. The court did not even respond, said, I ain't even responding to that crap. Exhibit B. So I'm assuming Exhibit B must be all the way at the bottom. Exhibit B. Oh, here goes Exhibit B. Here's the email from Ahmad to Miss Lisa Lott, our honorable judge. Here's a proposed order for evidentiary motions under seal. So this was him sending the email. He just said, hey, I hope this message finds everyone well. Attached, please find a copy of a motion of file for evidentiary motions under the seal and the proposed order in the Word format regarding the same. I am providing the honorable court and all the parties with a copy of this motion to be filed. I hope I can hear back before 4:30 p.m. Thank you. I'm looking forward to hearing from you soon. And I guess the judge said, kick rocks, buddy. I am not responding to anything. So they didn't respond. Okay. On October 16, 2025, the undersigned counsel sent the court an email advising that a ruling was needed or pending for a motion before November the 3rd, 2025. That's Exhibit C. So let's look at C. That's A. So I guess it was things that she didn't rule on timely. Okay, so here it goes. January the 16th, 2026. Okay, no, Thursday, October the 16th, 2025. Okay, so now I'm trying to tell you, Judge Kelly and Chris and prosecutor, they all up in this email. Good evening. Attached, please find a copy of our motion that still needs a ruling. Honorable Court before our November 3rd, 2025 motions hearing date. Thank you. As it currently stands, our motion hearing can span over 2 days potentially. It would help tremendously. It would help tremendously if we could determine which motions the state has unopposed and streamline and focus of the arguments. Thank you. Damn it. Dang, just answer the stuff. Good grief. On October 22nd, 2025, the council sent the Honorable Court a copy of his file motion for subpoena return date via email with the request for date. Mr. Faust's counsel received no response, like the judge just ignoring him. The judge say, don't send me nothing. I don't hear nothing from you. And if I do hear something from you, it's denied. On October 24, 2025, the state sent the court an email regarding a joint continuance of a hearing within 24 hours, and even on a Saturday, the court responded to the state. On December 30th, 2025, due to lack of response from the court, Mr. Faust's counsel sent an email letter to the court inquiring on how best to communicate. Like, I just give up. I've been trying to email you. I've been filing all this stuff. I've been just trying to do all this stuff, and you just ignore me. So just please tell me, how do I communicate with the court? And as of this date, the court still hasn't responded. The court only responds to Mr. Faust's counsel via email when a notice of conflict is filed. Please see Exhibit F through G. Based on the court's pattern of conduct, the court is disinterested. Okay, she can give less than two about his innocence, about this case, and about giving a fair trial. Does not hold any regards of any of his rights and placing it in the hands of the scales of justice to secure a conviction, regardless of Mr. Faust's guilt or innocence. An impartial judge does not ignore the law, instruct the defendant's counsel to file briefs on said defendant's behalf to protect appellate rights, undermines counsel's lawful objections, refuses to enforce subpoenas, denies motions and counterventions of the law in favor of the state, despite the state's ethically and honorably advising that the law is unfavorable, and ignore the defendant's counsel's communications regarding scheduling matters, but promptly responds to the state. So, like, he been feeling some type of way about this judge for a very long time. And that's why we seeing everything that we seeing fall out in the courtroom the way we are seeing it right now. This makes sense to me. So they already have been bumping heads for a while. It's giving you life, drunkie. I'm glad my ratchet reader is giving you life, boo. I tell you, they say the only reasonable explanation for ignoring the law is in favor of the state. She's so far up the states, she can't see daylight. She cannot even balance the scales of justice. She's sitting over there with the state. She part of the state team. She might as well be over there with the prosecution team, is what my guy's saying. And that's what he's saying. He keep putting on record, like, I feel like I'm handcuffed. I feel like I can't do nothing. I feel like I can't try this case. Like, I don't feel protected in this court. My client don't feel protected. Don't nobody feel protected. Like he is putting, that's why he keeps saying that. Based on the court's disregard of the law, Mr. Faust's counsel now files motions with the purpose of preserving the issue for appeal, as the court has demonstrated that Mr. Faust is not entitled to the benefit and protection of the law. Like, really? As an officer of the court and a professional member of the bar, I have a good faith belief, based on the actions of the trial court, that the trial court is invested in Mr. Faust's conviction, regardless of his guilt or innocence. So he's saying, he's saying the judge, like, look, I think she invested on seeing a guilty verdict. Maybe she running for something next year. I have no clue. I don't know. So we all want justice for Miss Baker, but not at the expense of dishonoring her memory with a false conviction. If this matter continues to be presided over in a manner that puts the interest of or favoritism for the prosecution and law enforcement over the interest of finding out the truth for Miss Baker family and the defendant's rights to a fair trial, a conviction is guaranteed regardless of the evidence. Like, that's what he's having, like, really a big problem with, because, you know, the evidence is going to really, like, speak for itself. You know, or the lack of their evidence, right? Because we saw 3, you know, all this pube hair and all this hair. We saw 3 containers of evidence open up and there was no evidence. Why? That seems like, you, as the judge, you would not want to mislead the jury. Like, that shouldn't have even been able to come in. And, you know, even when he was saying that he wanted to suppress the evidence, that evidence was not, she did not allow them to suppress the evidence. Like, there's nothing in there. Why are we showing empty containers with nothing in there? Just having the guy on the stand cut it open it up. And remember, technically, he said they don't technically open all this stuff up until after the end of the case and they're about to send it back to the jury room. And so he asked the judge yesterday, well, should we open all this stuff up and make sure stuff is even in there? And, you know, the state was like, well, no. We shouldn't do that. We got to introduce the evidence, and then that way it can be opened up just to show it ain't nothing in there. So, yeah, he filed a motion. They filed a motion to disqualify the judge. This happened on January the 16th, 2026. So this is like a couple weeks before the trial. So, you know, everybody coming in there butt hurt. You know, because she's seen all of this. She's seen everything that they are accusing her of. And that's why I don't understand this whole thing about, hey, you can get the judge taken off the case, but you got to send it. But the judge that you want taken off the case is the person that's going to read over it and decide whether they get taken off the case or not. How in the hell does that work? That don't even make sense. That seems like you just in a loop around. And just so y'all know, this is not in Fulton County. This is in Georgia, but it's in Athens, Clark County. So it's not in Fulton County. They probably next door to each other or something. I don't know how close they are, but it's not in Fulton County, but it looked like they got some Fulton County stuff going on. So let me see what else they got. So these are the reasons they put them out. So the identity of capacity. So he's just saying who he is. Purpose of the oath, his verification of that. Then he's stating why. Once again, just summing it up. Restriction on filing legal brief. Right? So he's saying during the January 15, 2026 hearing proceedings, the court instructed undersigned counsel that he was not to file any legal briefs following rulings by the trial court on behalf of his client, Mr. Faust. What do you mean? Refusal to reconsider suppression order despite state's concession. So it sounds like the state agreed to it and she refused to reconsider it. So on January 15, 2026, the trial court refused to reconsider its order denying Mr. Faust's amended motion to suppress evidence obtained due to illegal search and seizures, despite the state conceding that Mr. Faust's traffic stop and DNA obtained from the same was unlawful due to unfavorable controlling law in the initial hearing. So I guess my question would be is that when they're saying that the searches and seizures were illegal, they're saying that the state conceded that Mr. Faust's traffic stop and DNA obtained from the same was unlawful. This is not the DNA that they're using in order to try to convict him, not the DNA that they were not supposed to have. Please tell me this is not what we're doing here. This is not what we're doing, right? Denial of hearing of motion of reconsideration. The court refused to provide Mr. Faust with any hearing on the ground alleged. You said China custody with that in the motion of reconsideration, despite the state's prior concession and discovery of the new evidence supporting additional grounds. Chain of custody with that. They talk about the Dahlberg motion regarding the microscopic hair analysis. So on October 2nd, 2025, Mr. Faust filed a motion to exclude Larry K. Peterson and any other hair analysis testimony that want to come in here. Shit, why they want to have hair analysis testimony come in? We ain't got no hair. Instead of granting a hearing on this ruling on the merits, the court initially denied the motion based on the state's representation that it would not call Mr. Peterson, then orally stated the evidence would be suppressed for that reason, but further instructed that if the state later just decided to change their position, defense counsel would have to file a motion at that time. Ain't that about something? Failure to enforce a lawfully issued subpoena. So during the November 13, 2025 other SA Acts hearing, the court refused to enforce Mr. Faust's lawfully served and filed subpoena for the material witness, Brenda Sweeney. Refusal and recognize speaking objections. During the November 13, 2025 other SA Act hearings, the court refused to recognize undersigned counsel's lawful speaking objections. She said, there ain't no such thing. You ain't doing that in here. Compelled to disclose of cross-examination strategy. During the November 13, 2025 hearing, the court required counsel to explain the purpose of his cross-examination in the presence of the testifying state witness. That's what she kind of did today, y'all. She let that witness sit on the stand. She wanted to know exactly what line the court, the judge, and also the prosecution team, if y'all recall, they had that witness on the stand and they wanted to know what questions he was going to ask the witness. Where was his line of questioning going on? That seems like the same thing. Compelled to disclosure of cross-examination strategy. It's the same thing. So the court required counsel to explain the purpose of his cross-examination in the presence of the testifying state witness, despite counsel's request to continue questioning or to proffer the relevance outside the presence of the witness in order to, pursue a credibility-based line of cross-examination. She denied that. That's the same thing. I feel like she did that today. Number 10, denial of right to proffer excluded evidence. Remember, we read that earlier in regards to her denying him to proffer. Disregard of controlling law of evidentiary proffers. So we heard about that earlier. A pattern of non-responsiveness to the defense communication. The court has demonstrated a pattern of ignoring communication. She just said, fuck it, she ignored them. For an undersigned counsel regarding pursuing defense motions. The court has engaged in counsel only when the court's scheduled dates conflict with other judges' scheduling, while responding promptly to the communications from the state specifically. So, and they put the dates, the October 2nd, 16th, the 22nd, the 24th, December 30th, all these times that they've been trying to get in touch with the court. But the court don't respond to them. The court only responds when they have conflicts of dates, and they always respond to the state, according to him. And then they just testify to the truth and accuracy. And then he signs his name, it's notarized, and then he has his exhibits. These is all his emails and all of that great stuff in there. I'm still here. Oh, look, it took the page now. Okay, this is something else that I wanted to show y'all. So right here, this is a jury questionnaire. So I know that if I'm not mistaken, y'all have to remind me. On our jury, we have what, 8 men and 4 women? Am I getting that right? I can't remember. I think somebody put it in our chat earlier in the other room. So these are the questions that the jury had. Okay, so it's 8 men and 4. So, okay, highest level of education. That seems pretty standard. Do you have any problem with understanding English? Could you be a jury could you be a juror if we were asking you these questions? Are you currently taking any medications that might interfere your ability to concentrate? I would be off this jury. Do you have any problem with your vision or hearing or any other medical issues that would make it difficult for you, difficult or impossible for you to serve as a juror on this case? If so, I need you to explain. Have you ever been seated on a jury before? If yes, please explain what kind of jury you've been seated on. Have you been on civil, criminal, both? Is there anything about your prior jury service that might affect your ability to be fair and impartial in this case? Are you currently a student? Are you post-certified in law? Are you a post-certified law enforcement officer? Are you or another in your immediate family an active member or veteran of the United States military? Have you, any member of your family or close personal friend, ever studied or received training in medicine, psychiatry, psychology, social work, or counseling? Have you or any member of your family or close personal friend received any training in law enforcement or criminology? Have you or any member of your family or close personal friend ever been involved with any group that advocates or provides support for victims of crimes? Drunky, is this what the jury thinks the questionnaires look like? Do any of these questions remind you of, I don't know if any of y'all, the only person I know that's in our chat that's really been on juries is Drunky. So I don't know, but if any of y'all ever been on jury, does these sound like familiar questions? I've never been on a jury, so I don't know. Hey, welcome in, user. Yep, that's what they look like. Okay. Have you or a close member ever been arrested or charged with a crime, a victim of a crime, employed in law enforcement, corrections, or prosecution? Oh, do you know or have you had any contact or relationship of any type with the defendant in the case, Edrick Lamont Faust, or any of his family members? Oh, so they even asked you if you have a relationship with him. You had a relationship with him. To your knowledge, do any of your close personal friends know him? The prosecutors in this case are such and such, such and such, such and such. Yoko models. Nah. Do you know any of these people? Are you employed or related to any member in the Clark County District Attorney's Office? I need to know all this stuff. Do y'all have any of this stuff? Is any of this stuff going on? Have you, any member of your family or close personal friend, ever been a victim or a witness or arrested or charged with a crime? If yes, you need to explain what type of crime it was. Do you have a financial or other interest or stake in this case and outcome such that you would stand to gain or lose anything depending on how this comes out? Yeah, I'm going to write a book afterwards. Do you have any knowledge of this case gained from any source? Do you have any knowledge of this case gained from any source? And then they list the sources. Let's see. They ask them, can they stay off of Twitter and Facebook and all that good stuff? Have you ever visited the home of any of these people? Have any of the following persons visit your home? Did you or any immediate member of your family attend the University of Georgia Law School? Have you ever been questioned or had a family member questioned in regards to the death of Tara Baker? Did you ever provide a DNA sample? They nosy. Dang. They got all these people on here. You got to determine if you were a friend or if you know. I'm assuming it's going to be a lot of the people that's going to be called to testify, y'all. Are you now employed or have you ever been employed with the University of Georgia Law School? That's interesting. Oh, okay. Okay, one more thing that I wanted to show y'all. That I thought was interesting. So what we have here, this was filed on February the 2nd, 2026, dated January the 12th, 2026. This is a plea deal. They offered him a plea deal, y'all. They ask you if you ever watch Forensic Files. Yes, I watch it every day. So this is the plea deal that they offer him. So y'all know he got 12 counts. So for count 1, malice redrum, life in prison without the possibility of parole. I don't even know how this is a plea deal. Count 2, 3, 4, and 5, they are all felony redrums. They were going to vacate for sentencing purposes as matter of the law. Count 6, burglary, 20 years confinement concurrent with count 1. Count 7, aggravated sodomy, life imprisonment with the possibility of parole concurrent to count 1. So I guess if he would have accepted this plea deal, I mean, he was gonna have life in prison with the possibility of parole for count 1, 7, 8, 10. I don't know what the hell that. You say 20 to life? Is that what it sounds like? Because then I see the arson and say 20 years of confinement. What is their life without parole limits? So they did offer him a plea deal, but he denied it. Of course, that's why we had trial. He said no. I don't blame him either. Like, fuck no. Nope. Let me make sure nothing else has been filed. Oh. Yeah, you want to see this? This the contempt order. The judge can wait to sign that. The court had defense counsel in direct contempt based on the defense counsel's multiple willful and intentional violations of this code right here, 24-4-412, during his opening statement. He got held in contempt in opening statements. God damn. That sounds crazy. That is just like unbelievable. Counsel was warned of the violation prior to being held in contempt, and defense counsel was afforded the opportunity to respond after the state's motion, asking the court to find the defense counsel in contempt. Defense counsel and his co-counsel both stated on the defense counsel's behalf that the violations were unintentional. The court hereby finds the respondent in contempt and orders that the respondent pay $1,000 cash money in my hand. It's by February 9th. So he got all the way to next Monday. I thought she told him to have that money in the courtroom in the morning by the time court started. But I guess she gave him a little time. She said you can have it in on about February 9th. OMG. Yeah, so there is your order of contempt. Contempt, he got it. Oh, it was for real, for real. She wasn't playing with him, and she said she wasn't taking it back. She told him today, don't be late for court. Let me see what else they got in here. That's a whole bunch of motion and lemonies. But they were excusing a lot of stuff, but they definitely got a lot of stuff up in here. But that's what I wanted to. So I guess when we looking at this case, we can understand they got a history of some stuff that's going on. People have rubbed people the wrong way in regards to this. It seemed like we got a prosecution team that's kind of like with the defense team, and then we have a judge and a defense team, a defense attorney that just really they not messing with each other. Like they cool on each other. So that's what we have going on in regards to this case. So I guess we can kind of see it from both ends. It seems like they both irritated with each other to the 5th degree. But unfortunately, although he may be frustrated, and I understand, when you feel self-deflating, like it's just, yeah, he got fined $1,000, Derek. The judge wasn't playing with him. Have that money up in my hand. You just not go file you in contempt and rush me that $1,000. And that's because the prosecution team wanted him to be held in contempt. And they just have such a bad history. And remember, he asked for the judge to be removed. So she might be a little salty. They want to try to act like they don't be salty about that. But she probably salty. She probably salty. So I just want him to, I do want him, I know he has stated on the record that he feels like he's being mistreated, that his client is being mistreated, that this case is not being fairly tried in the courtroom. It's been noted for the record. I mean, right now, I just want him to concentrate on like doing the case. And I think that he has enough stuff on here that if we need an appeal, that an appeal will happen. Yeah, she is the chief judge. Yep. Yep, she is the chief judge. And of course they did deny taking her off the case. So that's why we're here. But they got a lot of, bad history with each other. If it comes from her denying motions before, not listening to their motions, not helping them with subpoenas, not responding to different things that they're putting in front of her before the court date comes up. They got a lot of issues. Did he say those things in court today? Yeah, Judge Shamrock. Yeah, he did. He said that he feel like he is being handcuffed, and he feel like this is Russian law or something. And he went out on these little tantrums. Like, I thought he was gonna start jumping up and down. I mean, I get it, but I mean, we already know that the judge not messing with us, right? The judge is not messing with him. And he's saying, how unfair and how biased she is, and how she's letting the state do certain stuff and he can't do certain stuff. And I just think that it's just so much. But I want him just to concentrate right now on the actual case. And I know it got to be hard for him to do. I know it got to be hard because it's a lot. Yeah, it's definitely worth a rewatch. I'm trying to break it down in some ways for y'all to be able to get to the stuff without the fluff. I don't think it's really that much fluff in between besides me screaming, because I did a lot of screaming today. They had a witness on there that I wanted to pull my hair out, Just Shamrock. Our last witness of the day, she'll be on there tomorrow morning. She almost made me want to come through the screen and pop her. And the judge, I don't like when the witnesses is on the stand and the judge like chastise or whoops the defense attorney or the prosecution attorney or the prosecutors, for that matter of fact. Like, I think certain stuff should be handled behind closed doors. I don't think that we have to handle that stuff in front of the witness. Why show a witness that you don't respect me or that I did something wrong? So when I'm questioning the witness, she's sitting up there with her little snarky ass and she rolling her eyes and, do I really need to listen to that? And, I was trying to tell you that, and you're going to have to come better than that. Like, who is you? But see, the judge had got on him in front of this witness. So I think it leaves him at a disadvantage when they do stuff like that. Like, I would love for you to send the witness out just like you send the jury out. That way they don't know what we're discussing. They can come back. Yeah, that's it, Just Shamrock. That's always been my motto. Like, look, tell me what I did wrong in private. Like, I am never going to bash you in public. Like, I just don't see even when I'm dealing with my day-to-day, like even with like things that go on in chat, like I am not trying to call nobody out in the chat. Like, I may email you, I may do a whole bunch of other stuff. You may be dead wrong, but I'm not here to put nobody on blast. First of all, it makes you feel uncomfortable. It's like belittling a person. And she literally she does this all the time. She do not send the witnesses out while she's belittling him. And she may be right in all ways. I ain't not saying it. And she not. it's just the way that she goes about it. It's just, yeah. So now this witness, she on the stand and she up there all snarky, like, why do you want me to listen to it? That's not what I asked you, ma'am. Can you listen to it to refresh your memory or not? Like now she want to change up her answer. She snarky. I guess is a nice way to put it, but I wanted to come through the screen. And I'm like, even at the end of the day, they did about 30 minutes of arguing after court was over today, Judge Shamrock. Oh, and all of y'all too, but they did about 30 minutes worth of argument, and they had her sitting there for parts of this argument. And I'm like, send her home. She got to come back tomorrow. Like, send her home. We're not questioning her anymore. But so yeah, I wanted to kind of, because now she feel like she floating on cloud nine, and you can see like she's looking at the state, for the state to do objections, and then when the state finally does an objection, she looking like, like she called the objection or some stuff, like she running some shit. Like, yeah, nah. I'm so over her. I'll be glad when she get off the stand for real, for real. Yeah, she is the last witness of the day if anybody wants to look at her. Kay says, the judge has, let me see. I got to put it up here. The judge has effed up and she knows it. She will be completely bury herself before too long. She's a snake and she needs to be yanked off the bench. God is in that courtroom, Faust and Cruz. Yes, like, I just need him to keep his composure, Katie. He got this. But I that's why Mr. Hall had to stand up and say, look, I agree with Mr. Cruz. Like, we do not have to show our hand to you. So them objecting because they think I'm going to go someplace is not fair. You object if I go that place. Like, then you raise your objection. But for you to object before I can get the words out of my mouth, like, what are we doing here? And I don't have to tell you my strategy. I don't have to tell you what I'm doing. Is Mr. Hill or Mr. Hall? I don't know. He been so quiet over there. The judge, when he stood up, the judge said, who you be? Who you? I know you been sitting over there at the defense table, but who you? What's your name again, homie? You say defense should call sidebars and make sure it's on the record. Yeah, Derek, and I think that's what he's been trying to do, because if he's trying to do these non-speaking objections, but what the judge will do is she will allow them to come up to the bench. She doesn't have a problem with them coming up to the bench. So the judge allowed them to come up to the bench, but then she'll have the witness still in the witness box, right? And she'll send the jury out. So the jury not there. But that witness that they questioning or they got some beef over, that witness gets to hear what this argument is about. And I think that you can kind of form your idea around that. Like if I'm sitting on the witness stand and I see them arguing about something I'm saying, and she wants justice for her friend that her life was taken, right? So she wants justice for her friend. So I can see her kind of like, being a little evasive. Like, I want to be like, I want to treat her like a hostile witness. I don't know. But I think they thought Edrick would take the plea. And now he's being punished for not. Yeah, and that could be very well possible too. Yeah, they offered him a plea deal and he said no. And that's because they want anybody to go down for something. But if you're truly innocent of a crime, you're not trying to be in jail for no 20 years for something that you innocent of. Like, what is you talking about, dude? Like, that ain't gonna work, not at all. In no shape, way, form, or fashion. So as we going through the trial, as we're watching tomorrow, I will have these documents up if anything comes through. Anything that's filed, because I wouldn't be surprised. Like, I don't know how often you can file for a judge to be taken off the case, but I will be filing the damn thing every day. Every day. Please take this judge off the case. This judge needs to relook at herself. Like, I don't feel safe in here. He didn't say it on the record. He said, I do not feel safe in here. My client doesn't feel safe. We do not feel like we're going to get a fair trial. Judge, please grant the motion. Grant the motion. He going to be asking for a motion every day. Every day throughout this trial. We've been in this case 3 days, y'all. And he has asked for a mistrial every day. It reminds me, I have so much PTSD from YSL, a little bit of Daryl Brooks in there. I'm like having multiple ways of PTSD with this trial. Every day he's going to ask for one. We are like going to sidebars and dealing with this legalese every 5 minutes. It is like so. And I know she's going to keep denying it because certain fact that, of course, she doesn't want to grant a mistrial with a jury seated. So they're trying to preserve all of those things. And I think she getting kind of salty more and more that he says, look, I don't feel safe in your hand. Like, I don't feel safe. My client doesn't. Today was the first day he was like, I don't feel safe. My client don't feel safe. We cannot get due process. Like, I'm like, oh boy. She said in some states, all hearings are supposed to stop until a motion to recuse is ruled upon. Well, see, that's the thing, Judge Sharon Rock. They did rule upon it. They ruled upon it before the trial actually started. That motion that I said to recuse or disqualify the judge, that was filed on, I believe, the 16th of January. So it happened before the hearing started, right? Before trial started. And they denied it. You know, she denied it. So... And I tell you, she denied it. And on the first day of trial, my boy already held in contempt and fined $1,000. You missed that? I missed the valid grounds for a mistrial, though. Yeah, I think that I just think that I think that he really feel like they're not gonna get a fair trial. And even though he's trying to be respectful, nice, but you know, when he gets to like being I don't want him to get to where he like a crybaby about everything, like nitpicking. Like he's like, oh, you know, Mr. Prosecutor, he doesn't speak to me in the hallway. Like, I don't want y'all to be best friends. I just want y'all to come in here and get the job done. There is no need for all of that. Y'all don't have to speak. I mean, you would want to speak. Y'all want to have a friendly relationship, right? But I mean, he doesn't have to speak to you, right? I guess. So, but when he started going into that, and each time she gives him an opportunity to talk, y'all, because he has not actually been able to get off his chest everything he wants to get off his chest in regards to the case, he keeps going back to the same thing. I hear it, you know, I just don't feel like we're going to get a fair trial, blah, 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 for my client. Like each time he does something or he says something, he goes right there. And the judge can't even address what he's saying because she has to kind of address that first. So, yeah. Yes, but he was in contempt, Sweet P. Yeah, he was. He was on the first day. He surely was. Says Sweet P, check out Judge Boyd and Jason Gross. They have a feud, but they still managed to work together just about. Yeah, I mean, and I get that. That's what I'm saying. Like, even though him and the prosecutor don't get along, The prosecutor, I mean, he's there because he wants to find justice for this young lady whose life was lost. And him as a defense attorney, I mean, like, guys, like, I don't know what that feeling must feel like to be accused of something that you really, really are innocent of. Because I'm getting that vibe, and I'm getting the vibe that even with that, his defense attorney really, really, really believes this. Like, I wouldn't be surprised if this guy don't cry in court. Like, I think that he may have a breakdown because, like, it just almost seemed like at the end of the day, when the people were gone, like, it was like he was at his wits' end. Like, I thought he was gonna hit his head against the table or something. Like it was just mind blowing. If you guys didn't see that, it's like in the last 30 minutes of our live that we did today. And I was like, oh my gosh, like, I think he's gonna have a mental breakdown because he feel like he being jumped on. You know, so I think that he's really having a problem with this, especially when he, you know, his client. I've never seen a defense attorney stand up and say the things that he said with so much passion and conviction. Like, I am trying to protect and defend an innocent man, and at the same time, I'm trying to make sure that the right person that needs to be charged for this case, I'm doing double duty. Thank you. For some reason, I thought in Georgia, the judge sitting on the case can't rule on their own recusal. Didn't the first YSL judge get in trouble for doing that? Well, Judge Shamrock, Judge Glanville did do his recusal, and he took himself off the case. He actually followed the rules and took himself off the case. So I think he did do it. Judge Glanville, I don't know if he really wanted to, you know, from him having all his damn secret squirrel meetings back there with damn little Woody or whoever. But yeah, I think he did recuse himself from the case, but they actually ruled on it. So what they do is they get, and it's stupid. I don't know why that's like that. It's like almost like you have to show the judge that you, what everything your hand, why you don't like this judge. This judge gets to read it and say, nah, dog, you stuck with me. I don't care how much you don't like me. And that's basically what I don't care what I did. That's basically what this judge did. But I believe Judge Glanville actually made the right decision, and I think that he actually took himself off the case. You said this judge reminds me of Beverly. So biased. Faust is not guilty. Yeah, Lou, I think that, and welcome in. Yeah, I think that, and see, I'm not a lawyer, so I don't know if I don't know, maybe that's what we need an attorney for, to kind of understand that portion of it, because I don't know how that works. Yeah, and I have to see what case that is. Beverly Canoni. What case is that? Reminds me of Beverly Canoni. You have to let us know. I be falsely accusing myself enough. No need for anyone else to bother. Right, Just Shamrock? Okay, wait a minute. K-Pick says Glanville denied the motion 2 times for the recusal. He didn't send it to another judge until after the inappropriate meeting with Little Woody, but Glanville didn't take himself off. Another judge did. Then took. Okay. Is that what happened? I thought he took himself off. Yeah, I thought Judge Glanville took himself off after reading and stuff, because I remember court was down for like, 2-3 months, and every dang on judge they tried to give it to or reassign it with. I remember during that period of time, they kept trying to reassign it to a different judge, and everybody was like, I don't want to touch this shit. Not me. I don't want no parts of this. I recuse myself before I even get involved. The only judge that would take it was the last judge, and I can't even remember her name. And she was like, she about to run this ship tight. And that's exactly what she did. And at the end of the day, everybody was not guilty, and everybody was taking plea deals, and everybody was just off. Okay, that's good to know. That was the Karen Reed trial. That was the judge in the Karen Reed trial. The first one or the second one? I don't know. I didn't watch Karen Reed trial. Dang. He needs to state the case law for his motions. I think he's trying to. Oh yeah, Whittaker. Whitaker. Was it Whitaker or Whittaker? Okay. Yeah, thank you for that information. Herself off because that meeting had possibility of bias. Yeah, like he is something else. You say all of them. Oh, okay. Yeah, I didn't get into the Karen Reed stuff. I was like, I don't know. It was just doing too much for me. I couldn't follow it. Whitaker. It's Whitaker. She came in and she was like a boss, like, okay, we're gonna do this way. She wasn't effing around with the prosecution team at all. I think she was so pro defense. She was like, they want to contribute to my fund and my campaign money. I ain't about to be bothered with y'all in this little bum prosecution team. Y'all brought all these defendants. What is wrong with y'all bringing 102 defendants up here in this court and think y'all can handle this? Y'all can't handle this. What is y'all doing? Got this whole mess. Everybody get a deal. I couldn't believe all that time we was watching. I was watching that case, and then everybody get a deal. You get a deal. She get a deal. Everybody get a deal. Deal. I'm like, what? That one guy got up there. I can't remember his name, and he forced a mistrial. Like, she was so done with that case. She was like, "You want a mistrial? All right. Well, if you want a mistrial, we can do a mistrial. Or do y'all want to work some stuff out with the state?" Like, she just left it up to them. Like, she was so outdone with that case and that bullshit that they had brought up there. She was done. She was like, I don't care what y'all do at this point in time. Let's get this done and over with. That's enough for me. He came up here and said this stuff. They didn't prep their witness right. All right, cool. Because he just said some stuff that can't be unring. So awesome. So I think that's about all I have. Yeah, it was so funny. Boy, I would never want to be in the case that long. People, the jurors, people getting evicted, all types of stuff. Like, every day it was like a saga. Then they was off court for like 3 months when that stuff with Judge Glanville, because he want to be back there with Woody. Like, he knew that shit. Like, he having all these improv movies. He's like, the names must be named. Oh, that case was so hilarious. I would have never watched it with y'all because I cannot stream a case that long. That is too long for me. But my guy, he was like, the names must be named. He's like, well, somebody go talk in my sanctuary back in, what do you call it? The sacrosanction? It was the secret squirrel sanction. It was something. He was like, it was his sanctuary. It was sacred. His sacred chambers. I was like, oh, shoot. Judge Glanville. But I appreciate everybody hanging out with me while I went over what I could in regards to these docs. I will keep them up because I imagine we're going to have some more motions and some more things being filed. He did some motions today, right? They just haven't put them in the file. So I'll look at them tomorrow and see if there's something that we want to go over and we want to dig into after we get out of court. Thanks to the mods. Thanks for everybody, the new subscribers, the new members, new chatters. I appreciate you all. Make sure you have your make sure you have your notification bell on. What's the other thing? The sub bell. I don't know. Just make sure you come back. It's cool. We don't bite. Look, we don't bite. Good times here. All right, guys. Well, I want to thank you so much. I am going to play our outro song so everybody can have their outro song over here for those that didn't get it. We'll do that, and I will see you guys at the top of the AM. She said 9 o'clock, and the defense cannot be late. Oh my gosh, they were late today, and she was mad, and she was rolling her eyes, and she was pissed before we even started today. I knew today was not going to go well for them because they already made her mad because they was 30 minutes late. So hopefully they'll have their stuff together tomorrow.
When Sweet P taps in, you know the courtroom lights go bright. Trials running long, but the family's here every night. Mars on patrol, chatter showing out. This little YouTube corner's what community's about. Therapist you know, steady holding down the floor. Behind the scenes magician, keeping peace like never before. A banner king, a rule keeper too. Every channel dreams of a mind like you. Jason walks in and the ladies lose control. Down to earth king with the warmest soul. Film freaks, kindness, man, it's always on display. Fair and sweet and cheering folks along the way. And Marilia from SA keeps the laughter rolling free. Joking, shining, keeping spirits where they need to be. We're a family in the chat, side by side through every trial. Sweet P leads the way with that fire and that smile. We debate, we laugh, we lift each other higher. This quorum crew is everything we admire. Yeah, no matter what the case so far, we're forever taking to trial. Take it to trial. Pretty brown girl, she'll tell you what's true. Sharp as a gavel, funniest in the room. Dr. Rachel pops in while she's busy running lines. Speaks her mind every time, cuts through like a knife. And Paula brings the energy, jokes flying fast. Helping Sweet P backstage, making every stream last. And Zach's chosen, causing chaos just for fun. The resident cheater, but we love him, everyone. Here comes Maddie, handsome, quick with the line. A comedy sniper with the perfect timing. And Lynn with the updates, always loyal, always tuned. If true crime news drops, he brings it to the room. We're a family in the chat, side by side through every trial. Sweet P leads the way with that fire and that smile. We debate, we laugh, we lift each other higher. This quorum crew is everything we admire. Yeah, no matter what the case so far, we're forever taking to trial. Take it to trial. Shamrock keeps us trending, replay queen. Holding down the algorithm like a machine. SD's razor sharp, loyal through and through. And yeah, she adores chasing nothing new. Drunky the bear with the white cloth way, managing volunteers like she runs the whole land. Cynthia brings inside, would take sharp and steady. Donna keeps it real, 911 and always ready. Tilly Bird's the fat queen, receipts on tap. Easy's new, but she blends right into the pack. Tennessee, hard-lived, try support her with pride. Melly shows up a family for cooking for his dog. A steady carrying presence through the courtroom fog. And Brooklyn in the house, always bringing that spark. Lighting up the chat like a shout in the dark. Baca loves her gram, speaks truth when it's time. Micrograms for metaphors, straight up sublime. Barbara, biggest supporter, heart kind and vast. Looking for missing kids, hope that truly lasts. Only fan from Singapore, flag name but sweet. Still shows up with love every time he takes a seat. And even the part-timers keep this place alive. Curvio, Irish Amy, Capri Law, Hellcat, our tribe. Hearts wide open, stories shared, holding space because we care. From every corner of the world we climb to spend these nights together, one trial at a time. We're a family in the chat, side by side through every trial. Sweet P leads the way with that fire and that smile. Mods and shatters, yeah, this love is something rare. A courtroom crew with hearts beyond compare. No matter what the case or file, we're forever taking to trial. To Sweet P in the mouth and the chat we adore. couldn't ask for more.
All right, guys. I will see y'all at the AM. I think 9 o'clock Eastern Standard Time. Yeah, 9 o'clock. She said 9 o'clock. Don't be late. Go to bed, SD, so you can wake up and be on time for court. All right, y'all. Peace.